All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for 3 cases. 2 of them will be by oral argument. The third case is J.D. Ray Anderson versus Iowa District Court for Woodbury County. That case is hereby submitted at this time without oral argument. Our first oral argument of the afternoon is Konchar versus Pins et al. And it looks like the parties are ready. Mr. Sherinian?
Thank you, Your Honor. May it please the court, and happy Mardi Gras. Your Honors, we have asked the court to remand this case for a new trial because the defendants repeatedly offered opinion evidence of our client's reputation without meeting the strict foundational requirements in defamation actions as articulated in State versus Hobbs and State versus Buckner. The defendants' first 3 witnesses, all of whom had moved away from the community many years before, were allowed to express their negative opinions of Ms. Konchar without any evidence of what comments they had heard, how many times they had heard them, or when the comments had been made. Before giving her opinion, Ms. Dotson, who had moved to South Dakota in 2010, was only asked whether she had the opportunity to discuss Ms. Konchar with other members of the St. Joseph's community. She then went on to claim that my client was a bully, she lied to staff and parents, etc. Ms. O'Connor, who had moved to Alaska in 2013, was only asked whether she was aware of Ms. Konchar's reputation during the time she worked there. She then went on to speculate about some incident that had first occurred. Mr. Carpenter, who had moved to Kansas City in 2017, was asked if he formed an opinion about her reputation while he was on the Board of Ed in 2010. He used that opportunity to claim that teachers never came to board meetings and that some teachers left the school because of Ms. Konchar. He then went on to give an opinion that her leadership style was through fear and intimidation. None of the witnesses were asked the basic questions that are required under Hobbs and Buckner. Had they heard comments? How many had they heard? Which comments? Among which group of people? The foundation testimony was simply not existent. The defendants then failed to connect these supposed reputation opinions to the statements at issue. The defamatory statements were that Ms. Konchar had committed, quote, serious irregularities in school administration, and she exhibited a pattern of conduct that warranted the non-renewal of her contract. None of the opinions which were elicited related to those statements or those character traits. Under State versus Hobbs and Rule 405, the foundational requirement is that the comments heard must relate to the character trait at issue. In this case, the opinions covered the entire gamut of her character, her honesty, her willingness to change, or her management style. None of them had anything to do with how she administered the school or a pattern of conduct. In addition, the defendant's questions of Ms. Konchar's reputation opened the floodgates for numerous incidents of conduct for which there was no foundation. While incidents of conduct are admissible under Rule 405, not only must they be relevant, but they also must be well known within the community. The defendants elicited various negative incidents, but never demonstrated whether and to what extent those incidents were known by anyone else in the St. Joseph's community or Des Moines generally. An example is Ms. O'Connor, who claimed that she wasn't properly reviewed a sufficient number of times. But there was never any evidence that
Your opposing counsel has challenged the preservation on these issues, and that maybe only 2 objections regarding that were preserved, in particular Carpenter and Bradley, and you're talking about some others. Can you address that?
we raised the factors in our motion to limine at the very end of the hearing. That's at page 1629. And then on the first day of trial, the court was asked specifically about that, and she stated that she was satisfied that the foundation had been met for Dotson and O'Connor. We believe our other objections contained that foundation requirement that were submitted. We had to submit a whole series of objections to all of the designated pages of the depositions that were played. Effectively, what happened in this case was that under the guise of reputational opinions, the defendant's witnesses were allowed to describe their opinions of her character without ever showing how those opinions or incidents were related to Ms. Konchar's specific reputation that the defendants had impugned. And the reason these foundational requirements are so important is that otherwise there's no way to challenge the witness. There's no way that a defendant or the court could determine whether this witness was talking about reputation or simply offering an opinion as to character. Yes.
In the defendant's brief, they bring up the issues of the First Amendment and the ministerial exception, and that should be a complete defense to all the claims. And could you address that, please?
There was no cross-appeal filed in this case. Judge McAllister and Judge Crane found that the first 2 statements were purely secular and that there was no religious doctrine that needed to be determined to decide whether there was a pattern of conduct or whether there had been serious irregularities in school administration. And so, number one, not only was the issue
on a different basis. I mean, if we were to conclude that those particular statements should have gone to the jury, then can't we affirm on that basis, and we don't even have to consider whether the reputation evidence was admitted properly or not?
I'm not sure that I follow your question, Your Honor. The only issue that's been raised in this case in regard to the religious exemption is in regard to the 2 pastors' comment.
Let me go back to the reputation evidence issue, and here's my general reaction after reading the briefs and at least skimming some of the record. It's a voluminous record. There was a trial. The defamation claims that actually went to trial are these pretty general things: pattern of conduct, serious irregularities, which would seem to me to open the door to a fairly wide range of evidence. And I would be reluctant to send this back for a new trial given kind of those circumstances. So what is it that's so compelling about that you maybe there wasn't just a technical legal error, but there was some sense in which you didn't get a fair trial? What was unfair about the trial from your perspective?
This is what I've experienced, unfortunately, on other occasions, and it's called death by 1,000 cuts. Evidence that should not be allowed in, that it doesn't relate to the serious irregularities, which was blacklisting and the wage withholding issue. Instead, what we have was effectively a character assassination through all of these minor incidents that had occurred years earlier and were unrelated to the issues that were being raised and effectively the reasons for the termination. So it's that avalanche of minor issues, all complaints from former employees, many of whom were disgruntled, that piled on and destroyed my client's reputation. When the court should have been very disciplined in allowing in only evidence that was relevant and only evidence that related to these particular statements.
Relevance is broadly defined, and we're reviewing evidentiary rules for abuse of discretion, and her reputation's at issue. And if the alleged defamation is serious irregularities, doesn't that open the door to witnesses testifying about other problems they observed in her, how she did her job?
There's a very significant difference between administrative reputation and, for example, reputation for honesty. And what the defendants did was ask several witnesses, what was her reputation for honesty? That had nothing to do with the statements that were made. That had nothing to do with the decision that was made. And instead, they made it any possible issue or any possible negative incident that they could find. But we believe that it should have been limited to the administrative issues instead of this broad gamut of character aspects.
Ask you specifically to address the prior two pastors were consulted claim. Tell me why that's defamatory, first of all, and second of all, how does it relate to this First Amendment issue that we've got?
Hominem argument, Your Honor. It was the two pastors have been consulted and Father Pates approved the decision. Effectively, the two pastors that the parish knew going back, I believe, 5 or 6 years were supposedly consulted and had implicitly approved the decision. And that was not true. Neither one of those pastors had in fact been consulted about the renewal of her contract.
Though, at some point.
Not at the time the statements were made. There was an investigation and they were asked questions during the investigation, but not.
To the pastors at any point?
My understanding was that he had talked to the pastors early on in his tenure, but the question was never posed to them, do you approve of her contract not being renewed?
I don't mean to interrupt. I want to try to make sure I'm being clear about what I need to ask you. It seems to me that if we get into the issue of whether or not these pastors approved the employment decision, that could conceivably entangle us into a religious process, or at least that is what the defendants are saying, and that's what I'm concerned about. So,
Argument, but what we were raising as part of that claim was simply the fact of consultation.
okay, so let me just be clear then. You're going to go back to the jury. If we reversed on that issue, you'd go back and the only issue for the jury to decide would be whether or not they were consulted?
We would hope that the other statements would also be part of this, but it would be part of what the defendants did to defame my client's character.
Defamatory about whether or not they were consulted. I think that's my question. I mean, I understand if you're saying the approval part too, but if it's just the consultation, I struggle with it.
Point. What we argued was this, that it was the fact of consultation, but the consultation in the context of that statement implied that they had improved the decision.
What if, one of the defenses is that the statement was substantially true. And so the statement was, please be advised that the prior two pastors were consultant and Bishop Pates approved the decision following the evaluation of the past conduct. Now, if you just ended it at the word consulted, that was true, right? Father Pence did consult.
We asked those two pastors whether they had ever been asked about Ms. Konchar before these statements were made, and they said no.
Father Pence had talked to them. He'd only been on the job a fairly brief amount of time, as I recall, and he had talked to both of them about what they thought of Ms. Konchar. Isn't that correct?
He testified that he had talked to them, but the issue was, had they been consulted about the termination or the non-renewal of her contract?
So I don't, I mean, I don't see that in this sentence. I see two different things. I see Bishop Pates approving the decision and the two pastors being consulted.
We're entitled to the implications from that statement, and that's what we were arguing. As a matter of defamation, effectively what the diocese was doing was making an ad hominem argument that these two pastors had approved that decision when in fact they had not.
Final step, I guess. So I understand, I think your piece about implication is that when those two clauses are together, a reasonable person could infer that the two pastors approved the termination. But why would that necessarily be defamatory? I mean, what additional impetus does that add beyond she was terminated?
Your Honor, what happened was that Father Pins had only been on the job for 6 to 9 months, and there were some serious questions about his credibility. So they were responding to this idea that a new pastor didn't have a basis for terminating a 20-year principal. And so this added legitimacy to their decision, when in fact it was not true. Your Honors, I would also like to touch on the breach of contract claim.
Touch on that when you come back around. We got a red light here. You get a second crack. That's okay. That's okay. I thought Mr. Ranch was going to go first. Oh, no, excuse me. We've got Brianna Long. That was the next case. Brianna.
May it please the court, counsel. Brianna Long here, and along with my colleagues Frank Hardy and Haley Hermanson, we represent Reverend Father Pins, St. Joseph Church, and the Diocese of Des Moines. Konchar here has raised 4 separate claims, issues on appeal rather, but at the heart of each of those issues is Father Pins' determination that she was not suitable in the ministerial role as a Catholic principal. And so we have presented a 5th issue that you've already talked about here today with Mr. Sherinian, an alternative ground for affirming summary judgment grounds and the jury's verdict based on the ministerial exception as well. And given the importance of those First Amendment issues, I do want to begin with that. Specifically, you've talked already about the prior to pastors comment. This was part of Father Pins' statement to the St. Joseph's community in an email. And plaintiffs have raised the implication argument that the statement, instead of saying the prior to pastors have been consulted, that they actually approved the decision. The district court correctly determined that to wade into those waters as to whether or not they were consulted or whether or not they approved the decision is impermissible entanglement.
Because, I mean, that seems to me like a fact. What we said in Coster, or maybe even I said it because I wrote it, is that if you can apply a secular standard as the standard of liability, then, then it's not under it doesn't fall into that exception, doesn't entrench on the First Amendment, whatever. So it seems to me, if all you need to do is say, is this statement true or not? If that's what the jury is deciding, are those statements true or the implications true or not? That's simply a question of fact. I don't understand what you're intruding on to answer a question of fact, right?
Honor, we certainly disagree. We think under the Supreme Court case law and the significant federal case law surrounding the ministerial exception specifically, anytime you're wading into the decision-making process or the determination of the suitability of a ministerial employee, you are looking into a strictly ecclesiastical matter. To award damages in this case, to get all the way to the end result, you would effectively be punishing the church for determining that Phyllis Konchar was not a suitable person to serve in this ministerial role.
push back a little bit on that, because I think what Justice Mansfield is getting at is it's one thing to punish the church for hiring or firing a principal. It's another thing for saying the church sent out a press release, so to speak, and that it had statements in it, and that those statements were false and defamatory. At least I can see a difference between those two things. Can you help me understand?
This particular statement we're talking about was in Father Pinn's email, not a press release, that was only directed to the St. Joseph's community. So we have that. Canon law actually directs Father Pins that he needs to inform his parishioners about the status and decision-making process of Phyllis Konchar as a minister. So we don't think that this statement can be divorced from the decision-making process of the suitability determination, and especially in light of plaintiff's implication argument, the approval argument. We think Judge Crane's ruling was clear.
What is it, Kleibenstein? I'm not sure I'm pronouncing it right, but it's the one where the spirit of Satan. That certainly sounds like you're getting into the church makes a communication calling a church member the spirit of Satan. That sounds like you're getting into doctrine there, and that didn't seem to faze us. I mean, we sent the case back for a trial.
There was a couple significant differences with Kleibenstein, and also not sure whether I'm saying that correctly. That number one was just a parishioner, a member. Here we're talking about a ministerial employee who the church selected to represent itself and run and supervise this Catholic school. So that's a significant difference. And then they're also talking about the decision-making process and the determination to terminate her from that role and non-renew her position. Kleibenstein was a statement about a parishioner in a letter. It was also widely published to an entire community.
What I think would be an easy case, let's say the email said Miss Konchar stole money from the school, and that's why we fired her. Does that fall within the exception?
Of course, those are not our facts here, but yes, under the federal case law and the ministerial exception, it would, because to determine that and to allow a secular jury or court to eventually award damages, or depending on the type of claim, reinstatement, any type of remedy there, you're effectively punishing the church for making that decision.
It's a defamation claim, so you're not punishing the church for making a decision. You're punishing them for what they said. And the truth or falsity of the statement can be determined without looking to any canon or doctrine. I don't see how. I mean, I'll let you answer, but I really thought that would be a pretty easy one, and we could start from there, but maybe not.
Don't have the complete circumstances of the facts, but the case law that this court has addressed, the ecclesiastical abstention doctrine more generally, talks about looking at the specific issues actually raised. Was there an opinion defense in that case? What are the facts related to potential actual malice? So I suppose to properly answer your hypothetical, we would need to know more about the actual arguments of the parties related to those statements.
On appeal, are you relying on a substantial truth defense for the two-pastor communication?
Get past that ecclesiastical shield, that was an issue raised below in a defense truth, correct?
I agree it was raised below. I didn't see it in the appellate briefing, though.
To the extent that the court gets past the ecclesiastical issue, yes, that would be our position.
Go back to this issue. So if I understand what you're saying, right, at least in response to this, is there's almost an absolute bar to a defamation claim relating to ministers. So a school can feel free to say anything it wants about its principal, and that's not actionable because there could be potential defenses about opinion, truth, actual malice, etc. That's what you're saying?
We're not asking the court to make any sort of broad determination, right? We are asking the court to determine on these facts that the ministerial exception clearly should have applied. As we discussed with your hypothetical, it's difficult to say, could there be a fact pattern where there's a potential defamatory statement and the issues raised there would not implicate the ministerial exception? I'm sure we could imagine one, but this facts here are so squarely within that exception, and we don't think the court needs to make some broad pronouncement here. We want to look at the particular facts of this case and a narrow holding on those issues.
Can I ask you a little bit more about the particular facts here? So, as I read your brief, we talk about there's the piece about consulting and the implication that the pastors agreed. And then we make the jump to canonical law and church doctrine. I don't exactly know how those two connect up. I don't know why we couldn't ask a jury to just make those determinations. Did they consult? Did they agree? Without having anything in there about canonical law. So can you help me on that?
Canonical law here in particular comes into play as to why the statement was made, which is, the issue is not so narrow. I don't think you can look at the jury trial and the way it proceeded in this case, and look at all the different religious personnel that had to talk about their decision-making, why they did it, what they knew, when they knew. Canon law informed their duties and what they felt, who they felt they had to tell and make a statement, that they felt they had to make the statement regarding why they made their decision. And so it's really this entire process wrapped into one. You can't divorce just consulted from that. And I do want to address something that came up with Mr. Sherinian's argument. The prior two pastors, Father Pins had direct conversations with him just in the months leading up. It was a very short time period. He came in July of 2017. She was non-renewed in March of 2018, all within the same school year, as was already addressed to the diocese investigation involved directly interviewing those prior two pastors. So we think it's indisputable that they were consulted, even if you think that it's a secular determination here.
Evidentiary issues. I'm a little bit troubled because I think it seems like Mr. Sherinian has a point that some of this testimony seems very stale, maybe not particularly relevant. So maybe address error preservation first and then tell me why it's on point in this case.
So we do think there's a lot of error preservation issues in this case. Konchar seems to be making several different evidentiary objections here. I know we focus on the foundation issue, but if you actually read her brief and look at the objections raised, there's speculation, there's 405. First of all, it's abuse of discretion standard, and Judge Crane set specific guideposts before trial and told the parties she was going to make a witness-by-witness determination on these issues, and we think she properly applied those guideposts throughout trials. There were some foundation objections sustained during trial, and we were required to lay additional foundation. Even if you get past the error preservation here, I do want to make the point that the trait at issue here is that broad. It was her professional reputation. We're not just looking at the statements when we're talking about the relevant trait here or what reputation is relevant. We cited the Mims versus CVS case, a Seventh Circuit decision in our briefing that talks about that exact issue. There was a doctor who tried to argue, well, it should have been limited to my prescribing reputation because those were the statements, the specific defamatory statements, and the Seventh Circuit found it was error to exclude that type of testimony about sexual harassment complaints and other issues that bore on his professional reputation more generally. So we think that's appropriate. We also think if the court's going to engage in some sort of statement-by-statement analysis of all the comments that Konchar has raised here, a significant portion of them were not reputational statements. They were asked, what is your opinion on XYZ? The case law is clear that that does not require the same foundation as a reputational statement, which is essentially mass hearsay. So a lot of it is not even in the reputational context, reputational bucket. We were in 405B territory here, which means specific instance of conduct were squarely relevant. We also have to circle all the way back to the fact that we were trying to prove the truth of a pattern of conduct warranting non-renewal, serious irregularities in her administration. And Judge Crane acknowledged that a lot of these statements and instances kind of bore on the underlying facts rather than just the reputational issue. I do want to point out, too, that a significant amount, all of the case law that Konchar has cited in the briefing is criminal case law. All of the case law cited, I believe, is 405A case law. And so there you're discussing whether or not someone's opened the door, whether or not cross-examination on a particular instance is appropriate. Whole different realm than a civil defamation case where it's squarely an element of her claim, reputational damage. So we think that that deserves a close look, and even if you apply Buckner and Hobbs and those factors, there was significant testimony laying foundation. I do want to also make the point that to your comment about evidence being stale, this case was somewhat a victim of COVID. We were set for trial in April of 2020. The statements were pushed, obviously, then to 2021 based on the closure of the courts. The statements were made in March of 2018. So when we're talking about 2014, it's actually not that big of a leap here. I also want to make the point that Ms. Konchar herself touted her reputation over the entire 20-year career, and she was the first witness on at trial. So anything defendants raised in response was in direct response to the fact that she talked about awards and accolades and different things throughout her entire 20-year career. So we think that Judge Crane properly exercised her discretion here and that the testimony was appropriate. It's also 6 specific witnesses out of 36 in this trial. We've talked about the voluminous record before you. We have not even given you close to all the witnesses that testified on various issues, so certainly no prejudice here. We were talking about a pattern of conduct. All the witness testimony from Dotson, Carpenter, O'Connor was reiterated in some form, shape, or form by other witnesses throughout the trial.
Supreme Court applied the ministerial exception to a civil defamation claim as apart from a wrongful termination or employment discrimination claim.
Decisions, Hosanna Tabor and Our Lady Guadalupe, related specifically to employment discrimination claims and said we're not going to address whether this extends further, but we cited you in our notice of additional authority. Oh, I see that I'm out of time. Justice, may I finish my thought? Thank you. The Starkey decision in particular that came out last year really goes through a deep dive into the federal case law on that issue, and the federal cases are clear that if it involves ecclesiastical issues, that really the foundation and the heart of that ministerial doctrine espoused in the Supreme Court decision should apply, even if the function of the claim is defamation. Thank you, and with that, we ask that the court affirm all decisions below.
Thank you, Your Honor. First, I'd like to address this issue of whether or not this was a secular issue that was articulated in this press release. Specifically, what we were talking about is the statement that there were serious irregularities in school administration under her direction. But in addition to that, the reasons that were articulated in the letter of termination was this issue of blacklisting and also the Wage Payment Collection Act. Both of those are obviously secular. But what the defendants tried to do was, after effectively acknowledging that these were secular issues, then they brought in affidavits from Bishop Pates, for example, that tried to bootstrap those issues into some sort of religious issue, and that whatever Ms. Konchar had done violated Catholic principles. What I think the court has to be able to do is look at the articulated reason at the time of the termination and make an objective decision as to whether there is any religious implication at all. And clearly in this case, there was none. And both Judge McAllister and Judge Crane agreed with that position.
That caught my attention, I would like you to address. I'm summarizing what opposing counsel said, but something to the effect of plaintiff was the first to testify. She testified about her awards, accolades, et cetera. More or less, I took that, my own notes say opening the door. Can you respond to that?
That's the argument they've made, but Your Honor, what we were critical of was that if this is an offer of reputational evidence, then the requirements under 405 is that they must be relevant, and more importantly, that these incidents of conduct must become part of the community's understanding of her reputation. There must be enough publicity or knowledge of these other incidents that they've offered that would make those part of her reputation. And there was no foundation laid that any of those incidents, in fact, were known by the rest of the community.
Doesn't Ms. Long have a good point that you're kind of, the evidence could come in through one door or it could come in through another door? I mean, it could be offered to show that her reputation was not as good as she claimed it to be, but it could also be offered to show that there were other forms of misconduct that supported the statements and made them substantially true.
There must be some limits on the truth defense. And those limits are clearly prescribed by at least relevance, but also in terms of time. A person's reputation is not stagnant. A person's reputation changes over time. And to dig into some incident, whether there was a quarrel about whether a teacher was wearing bright yellow hot pants.
South, if they're raising some nitpicky thing that she did 10 years ago, I mean, they're going to hold that against the defense.
What I talked about earlier when I talked about a death by 1,000 cuts, it was this avalanche of things that had nothing to do with the administrative issues at the time, but every gripe that any witness could possibly come up with. And so for that reason, what we really want the trial court to do is be much more disciplined in terms of whether these specific offers, and most of this testimony, what we're talking about are these depositions that were submitted to the court ahead of time. The court should have been much more disciplined, as the district court was in State versus Hobbs, and said very specifically, there's no foundation here for this. That evidence is inadmissible. So
This two pastors thing that they got summary judgment on again. The issue there, I think I understand, and maybe it was Justice May who's helped my understanding. I guess the argument there is whether the statement is true or not, that's a secular issue. I mean, that whether somebody was, whether two pastors were consulted and approved the firing, that narrow part of the defamation case, that's clearly a secular question. But the significance of that, in other words, whether it's defamatory for them to say that two pastors were consulted and approved the termination implicitly, whether that's defamatory or not, maybe that requires you to delve somewhat more into the church and its doctrine. In some circumstances that might be defamatory, in others it might not. How do you answer that?
Well, as I think I explained it in response to Judge McDonald's question, it was effectively an ad hominem argument. And effectively, they were trying to create legitimacy by implying that the two prior pastors had approved this decision, especially given the fact that Father Pins had only been there for 6 months. So that's why it was defamatory in the sense that they were approving the termination or the non-renewal of our contract.
Really draws us into a question of whether the termination was illegitimate.
Because it's simply the fact of consultation that is the premise of all of that. It's that implication issue. Your Honors, if I might summarize. What we're asking this court to do is to send this case back to the trial court so that the court takes a much more disciplined view of how opinion testimony in regard to reputation should be admitted, and that it only admit testimony that is established by foundation, but also that the incidents of conduct end up being only those that were known in the community, so that we have a much more efficient trial and one that's based on evidence that truly goes to this issue of whether there were administrative irregularities or a pattern of conduct. Thank you.
The case of Konchar versus Pins is hereby submitted. And we'll have a brief transition here for the next case of LS Power versus State of Iowa and Mid-America Energy.